Hello friends, in the series on the income tax cases, today we will discuss a case which throws light on the importance of approval under section 153D in cases of orders which are passed under section 153A and 153C. In the Income Tax Act, the concept of approvals have been there just to avoid the high-pitch assessment orders by the assessing officers or the high-handed assessments by the assessing officers. The purpose of the assessment is to determine the right tax for the assessee, and when the assessment proceedings are going on, then it is not a list between the assessee and the assessing officer. But it has been observed that while these approvals are given, they are just given for the sake of rituals, and due to which the assessee has to bear the burden of high-pitch assessments and very high demands created on account of various assessments which have been done by the various assessing officers. In this case, which has been decided by Delhi High Court in the case of Principal Commissioner of Income Tax versus Shiv Kumar Nayyar, it has been concluded by Delhi High Court that when an approval can be termed as mechanical or ritualistic. In the present case, which has been reported in 467 ITR at page number 186, and the date of the judgment is 15th May 2024, the assessee assessments were done for the assessment year 2011-12 to assessment year 17-18 in consequence to a search on the assessee. When the assessing officer went to the Additional Commissioner of Income Tax to seek his approval, the proposal for approval was given to the Additional Commissioner just 2 days before getting his approval, and the Additional Commissioner gave his approval in one letter for all the assessment years. And in the present case, it has come into the picture that through an RTI, the assessee has obtained the information that when the approval for the assessment orders for the assessee was given on that day, the approval for total 43 cases was given. The assessee was contesting the assessment orders on the ground that since the approvals are given through a letter, and since 43 approvals have been given in a single day, so it can be safely assumed that these approvals are mechanical in nature, and hence the assessment order should be quashed. The tribunal has already given the relief to the assessee, so the revenue was before the High Court, and when the High Court heard the matter, the High Court was of the opinion that on the reading of section 153A subsection 1 clause B and section 153D, there is word each assessment year, and so it can be safely concluded that the intention of the revenue is that the Additional Commissioner should give the approval for each year separately and for each assessee separately. The High Court said that in the present case, although there is a manual of giving the approval, and that manual is applicable for section 158 BG, but that approval is equally applicable for approvals under section 153D, and which lays down some guidelines before giving the approval in the such cases. And one of the guideline is that the assessing officer should take the proposal for the approval well in advance. But in the present case, since this proposal was given only 2 days back, so it can be said that the Additional Commissioner was pressurized to give the approval in a hurriedly manner. That manual also prescribes that each assessment order which has been passed under section 153A should also mention in the assessment order that the approval has been obtained. So, from this case and in the present case, Delhi High Court upheld the order of the tribunal which has quashed the assessment proceedings on the ground that since the approvals for various years have been given in a single letter, in a single approval, the whole assessment proceedings were quashed and Delhi High Court upheld the order of the tribunal. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Shiv Kumar Nayyar. And this case has been reported in 467 ITR at page number 186. And the matter has been decided on 15th May 2024 by Honorable Delhi High Court. Thank you, friends.